people need to suck it up, realize they've got a hard job to do, and get it done in a timely, proficient, professional way. And I'm not buying the sympathy stuff on behalf of the people that have to do their job.
What you just heard is the Honourable Judge, who captured the world's attention with his sharp words on carrying out executions for capital offences. But that's not all he said. And in this video, we are going to discuss his decision. Will it benefit victims of the state of Oklahoma, USA, especially after the update of these two moms who were found murdered there? Hello, all you legal-minded friends. Welcome, new subscribers, members, and replay viewers. I'm Karen Cole from Legal Minded Friends. So, what is going on, and why did this motion get world attention? What motion am I talking about? Well, there was a controversial motion filed on the 30th of January, 2024 by the Attorney General Drummond and the Oklahoma Department of Corrections to the Court of Criminal Appeals of Oklahoma, USA. The Honorable Judge is responding to the joint motion to set Phase 3 of the execution dates from 60 days to 90-day intervals. The reason given in the motion, in a nutshell, is that it is too onerous and not sustainable to carry out the executions within the 60 days, and they want it increased. They argued to the court it is not sustainable because on the day of the actual execution, the penitentiary goes into near lockdown, but also because it takes 8 teams of people, each compressed of a multitude of individuals who need extensive training. They also need to perform mock executions in the days leading up to the execution, which means they need to go through a test run basically to ensure everyone knows their role. So their basic argument is this time frame of 60 days is a burden and not sustainable, and they want it increased to the 90 days. So why did the judge say suck it up? Well, this was originally said during World War II, where airplane pilots would say, suck it up, buttercup, because pilots had to wear an oxygen mask. And you can imagine flying was not as smooth as it is nowadays. When World War II started in 1939 and ended in 1945, the pilots would get sick in their mask. And if they did not suck it up, well, let's not go there, as you can imagine. But let me play the full clip of this judge, and then you can see if you can understand why he said this phrase, because understanding people's social reference can answer the why they say what they say. And if you've been watching my videos, we know only too well when people are on the stand and in court giving testimony, what they say and how they say it can be admired or criticized and interpreted by the jury, media, and members of the public. Examples are Wendy Adelson, how she kept repeating the question that the prosecutor asked. And do you remember Alex Murdaugh, how he started calling his son Pawpaw and made odd mouth movements? And every media said he had fake tears. Let's have a watch if you can't remember.
And Pawpaw got so many threats. Didn't take serious. Think twice about. So I'm just telling him, Pawpaw, I should have known.
Do you remember the very odd witness testimony by this guy? An example of an expert witness testimony that was admired was Dr. Curry during the Depp versus Heard hearings. And what you say in a police interview can be used against you. I have done a video on this comparing British law, Canadian law, and American law, and what the differences are when it comes to talking to the police and your rights. Check that out in my playlist. Okay, so now that you have that in mind, let's play a clip of what the judge said and see if you can tell why he said what he said, and then we'll talk about it.
In 2001, 18 executions were taking place, including 7 in January 2001. and at least 3 in another month during that year. In 2002, 7 executions with 1 month where 3 took place. And in 2004, 14 took place with the 1 month where 3 took place, and the last month in July, 5 took place. That Department of Corrections, that AG's office, those people did their duty. And I'm sorry, but I come from the Marine Corps, and when we have tough duties, we just say, man up. And if you can't do the job, you step aside and let somebody do it that can. We've got a stack of cases here, and you're giving us a lot of sympathy. But people have signed on to do their duty. And as hard as it is, I'm not trying to be macabre or anything of that nature, but it is a duty the legislature has determined to do. And if those people, those professionals, those leaders from 2001 to 2003 could carry out their duties in such a professional way without a hitch, then why cannot the leadership that is in place today perform their duties and perform these duties in a logical, reasonable, timely way to determine that the laws of the state of Oklahoma and the judgments and sentences that have been issued are going to be executed? It doesn't make sense to me, because I've seen other people with right leadership do their job without all the sympathy talk, because they have to man up and do their job.
Judge Lumpkin,
It's almost like we're being pushed, and I'm sorry for the analogy, but the only analogy I could come up with is the undisciplined child that keeps pushing the envelope. We set a reasonable amount of time. I thought at the time it was too much time, but we set a reasonable amount of time to start this out, and y'all keep pushing it and pushing it and pushing it. And who's to say that next month you won't come in and say, I need 120 days. This stuff needs to stop, and people need to suck it up, realize they've got a hard job to do, and get it done in a timely, proficient, professional way. And I'm not buying the sympathy stuff on behalf of the people that have to do their job.
Wow, there is a lot to uncover. And each time I listened to this, I had a different view. Now, the judge goes all around the houses, which is an expression that means taking longer than necessary to say something. So let's go through what the judge said. I thought I'll give you a backdrop of going around the houses while I tell you the key points of what the judge says. And then I promise I'll get to why this is important for victims. So the judge starts off reciting what has happened in the past history regarding the number of executions, as the motion detailed this information. But he quickly compares that to the previous Department of Corrections and those people who did their duty. He personalized it by comparing his experience in the Marine Corps, which refers to the military corps, but the P is silent. So he says when they had tough duties, they had to man up. And he further doubles down and says, if you cannot do the job, step aside and let someone else that can. This suggests to me that the judge is not buying the burden argument, and we all know about the amount of red tape and boxes that have to be ticked nowadays, and the increase in our workload responsibilities without allowing increased time. And stats show workload stress decreases productivity. How many watching know what I'm talking about? So the judge is taking a view that a sympathy element is not a reason for the court to increase the time of the executions. And many judges feel that if the problem is a legislative issue, then the legislation has to address it. And this honorable judge is clearly saying this is a leadership problem. He is saying that even when they originally set up the time between intervals of the executions, he felt the time they had set to schedule intervals between executions were given too much time between them. And in my view, I think what he's saying here is once all the appeals have been exhausted, then the wait and not knowing would be daunting for inmates. And in addition, the unknown is difficult for victims of families to move on. And he is also saying, where does this end? He is concerned, would they ask for 120 days next month? In my opinion, when the judge says they might need 120 days next time, I think the judge is worried about the slippery slope effect, which is a course of action that is rejected, because if it's not, it basically leads to a chain reaction that could lead to undesirable ends. So you stop it while you can, and the judge has that discretion to do that. I like to think of it as, like a big snowball, and as it rolls down the hill, before you know it, it gets bigger and bigger and bigger, and then it's out of control. This leads us nicely to the actual victims and their families that will not have closure until their loved one's perpetrator's sentence is carried out according to the penalty sentence that they were handed down. The motion was requesting an extension for 6 inmates who received the death penalty sentence. All 6 inmates are currently on death row. But who are these inmates? On the screen you will see their names and the dates they were originally sentenced, ranging from 24 years ago to 19 years ago. That is a long time to wait for justice. As we can see, the names of the inmates are written as appellants on the motion. It doesn't address who they really are. When I did research, for example, I watched a documentary called The Disturbing Murderer, Kevin Underwood, on YouTube. They gave a very detailed account of what he did to a child, and they showed part of his police interrogation, and it was gut-wrenching how he took pleasure in luring this young little girl to gain her confidence. Then he took her life in one of the most horrific ways imaginable. I cannot even discuss it, as it is so disturbing. And the others are just as horrific, and I will leave links to the ones that I found in the description area below. I also found one inmate on the list where his behavior after his crime had a similar twist to the recent case of the 2 mothers that went missing, and I'll share that with you in a bit. But first, I want to quickly mention why what this judge did was so important, as I agree with his decision to throw this back to the legislators who represent the people, as laws should be for the people and made by the people. My short version of one of the greatest speeches by a president. Do you remember when Abraham Lincoln, what he said in 1863? This decision recognizes the separation of powers, which means there can be checks and balances. Just because judges have discretion doesn't mean they should use it. However, when it comes to family law, family court judges have to make very difficult decisions. And given the background of this recent case in Oklahoma, why on earth would a judge make an order that required a mother to travel through the middle of nowhere to do a custody exchange? Here, let's have a listen. Then I'm going to share something with you that I thought was eerily similar regarding one of the arrested perpetrators in this recent case to one of the named inmates who is on the motion.
Just how desolate this area is. We're here about 5 miles away from where that accident first took place. This is known as the Four Corners area. Now, Jilian, Kelley, Veronica, Butler were supposed to meet here at 10 a.m., but they did not make it there. Their vehicle was found about 5 miles north of where we're at right now. The signal is so bad out here that we actually had to move because we had SOS phone signal. Now, this affidavit has a lot to break down here, so stick with me on what we're taking away here. Now, Butler was in a custody battle with Tiffany Adams. Tiffany Adams is the grandmother of Butler's ex-husband, Wrangler Rickman. So they're in a custody battle, and Butler had a normal supervisor she's preferred. Her name is Cheryl Brune. She was unavailable, so she contacted Kelley to do the supervising. That's what that relationship was developed. Brune later then said she was available to supervise, but Adams told her to take a couple weeks off. An interesting note there. Now, Butler told Adams, as we said, 10 a.m. they were going to meet right here. Police did not find the car here. They actually were contacted by family members after they found the car those 5 miles away, as we mentioned. They found evidence of severe injury, blood on the roadway, Butler's glasses in the roadway, a broken hammer, and a pistol magazine, all found. That was found in Kelley's purse, but not the pistol itself. So clear evidence of a crime right off the bat. Now, OSBI interviewed the daughter of Cora Twombly. She's referred to as CW in this affidavit. Now, CW, is 16 years old, said she believed Adams, Colin, Cole, and Paul Grice were involved in the deaths and that Adams had provided burner phones. CW said the group was involved in an anti-government group here in the area called God's Misfits. They actually had regular meetings at the Twombly's. Now, Cora and Cole came back from the day of the murder at 12 o'clock. This is 2 hours after they were supposed to meet at this location. Cora and Cole Twombly told CW, that their daughter, to clean the truck and that she did not have to worry about Veronica Butler ever again. Now, before that, Cora and Cole actually blocked the road to divert Butler and Kelley to where Adams, Coleman, and Grice were. That's when the murder happened. So they were supposed to be at this location where we're live currently. They were then diverted to Adams. That's when the murder takes place. CW also confirmed with the OSBI that an attempt to kill Butler happened in February of 2024 in Hugoton, but Butler did not leave a house. A previous attempt to kill Butler happened back in February of 2024, just months ago. Now, Adams, also through the affidavit, we learned she bought 3 prepaid cell phones from the Walmart on February 13th in Guyman, Oklahoma. All 3 of those phones were pinged in the area where the car was located, then turned off and turned back near a dam 8.5 miles away. They found that dam just 8.5 miles away, as we mentioned, from the location of the cars. The dam had been dug into, they had hay, and that's the last spot those phones were pinged. All of this evidence that we just brought you up from the affidavit is why these 4 arrests were made. These 4 people were charged with murder, among other charges. Now, we were at a press conference earlier this morning. Here's what other law enforcement officials had to say.
From the get-go, once we arrived on scene, and we gained a little bit of information, that we felt this wasn't a random deal. All right, we felt that with some of the information coming in, that it was more targeted, and we started to look in those areas that we were pointed to.
And now we asked OSBI today as well if they could confirm that those 2 bodies were Veronica Butler and Jilian Kelley. They said they still cannot confirm that, but they did confirm both of those women are now dead. They have confirmed that. We're still waiting to hear when those identifications will happen. Lane.
So now let's look at the 4 who have been arrested, and all have been charged with being involved with the murders. I have put on the screen who they are and their ages, and this is a capital offense and should warrant the death penalty because of the aggravating factors. And now I want to bring your attention to an inmate on the motion list, where the judge failed to instruct the jury regarding the aggravating and mitigating factors. This failure was one of the reasons for an appeal. Richard Norman Rogem also appealed for having ineffective counsel, and I've highlighted him there on the screen, as his execution has been delayed due to appeals because of this trial judge failing to instruct the jury to weigh the aggravating and mitigating evidence when it comes to deciding and imposing the death penalty. So I think it's important to give you a little bit of background of this inmate on the screen that you can see that had all these appeals, because it appears to me that Tad Cullum, our recent case of one of the 4 charged in the deaths of the 2 mothers, who is, I might remind you, is the boyfriend of the paternal grandmother, Tiffany. He made a play right out of Rogem's playbook, as far as I'm concerned, and I'll tell you all about that right after I give you this inmate's background and what he was convicted of. So he was charged with a horrific offense against his 7-year-old stepdaughter in 1984. He maintains his innocence. The background is that the child went missing and was found the next day by a farmer. The evidence against the stepfather was mostly circumstantial. However, he and the child's mother were going through a divorce, and he had tried to reconcile with her. Tire track impressions were found near the child's body at the scene and matched his vehicle. The 2 rear tires and 1 front tire, but one did not match. One of the front tires did not match. This tire was replaced on his vehicle, and he told his co-worker to lie about the tire being changed. And he said, or else, Well, you get the picture. He was threatening him, and the co-worker refused to lie. So keep that in mind, that the co-worker was refusing to lie, as we will soon see an eerie similarity in a few minutes with the recent case. And just so as you know, the acts against his stepchild were so horrific that the appeal court felt failing to make a jury instruction regarding aggravating and mitigating factors would have made no difference as to the jury's verdict. That was on the 30th of March, 2001. So him being on the delay list is also heartbreaking for the victims' families of this child. Now, back to this recent case. The two mums go missing on the 30th of March, and on the 31st of March, 2024, now I'm reading from the probable cause affidavit, Tad Cullum, he tells Beasley, a farmer that he rents some land from so that his cows can graze, he tells Beasley, so Cullum tells Beasley that the people were looking at him for the disappearance of Butler and Kelley. He also told him that he did not want the police or people to cause problems for him. And he said basically regarding all the skid steer tracks on his property without a skid steer looked bad. Beasley said if anyone asks, he would tell them that Cullum had done some tree and dirt work for him. Well, does that sound familiar? As it's on the probable cause. So it tells us that he is not willing to lie for Cullum because the two mums' bodies were found on Beasley's property. So he probably thought, I'm not going to lie for Cullum. Just like in the story above with the changed tire, not many people are going to cover for you if you've been charged with murder. And what's up with all these grandmothers getting involved with their grandchildren's lives to the point where they are willing to be part of a conspiracy to commit murder? And I've got to say allegedly, because Donna Adelson has pleaded not guilty to the charges that she has been charged with. Well, in my playlist, Conspiracy to Commit Murder of Dan Markel, check it out, because I'm pretty sure in this case that we've been just talking about, there's going to be some conspiracy discussions as well, because there was a prior attempt to kill Veronica Butler. So check them out as I discuss conspiracy, and you'll find that quite useful. So I hope I've pulled this all together for you, and I hope you can understand why the families of these two beautiful mothers will be pleased with the Honourable Judge Lumpkin's decision, that he held strong on his decision regarding the execution intervals, given that victims already have to wait decades for justice when it comes to executions. Yet a perpetrator can make decisions to take a life of someone else with no disregard. Now, if I haven't convinced you of my argument, let's end with one of Oklahoma's witness statements from 4 months ago. I believe the last execution of 2023, and it illustrates my point.
11:29, I'm sorry. After the execution, we heard from the victims' families of James Lynch and Robert Jett, and all of them said kind of the same thing. They've been waiting 22 years for justice, and they say today they finally got their justice. They said they wanted to thank the Attorney General's office as well as the state of Oklahoma for carrying out that justice today.
Well, what's your thoughts after watching that? Pretty moving. And now, do you see how delaying executions by extending the intervals is not a good idea for all involved? Please leave a comment. I love to read all comments, and be respectful. By leaving a comment, you may help someone else that will read your comment. And of course, I love to read all comments as they are valued, and together we can be more informed. And this information may help you or someone you know. In the meantime, on this channel, you'll find a variety of playlists to suit every curiosity about the justice system. And we provide you with a visual to information and the process. Going through a legal worry is devastating, and the Who Knew and Why Me playlists are designed to help you or someone you know. So please like this video if you like this kind of content. Hit the subscribe button and the notification bell if you want to be notified when I'm going live or upload another video. I'm Karen Cole from Legal Minded Friends. Information is power, meaning if you know something, you can make decisions that are right for you.